Mr. Murphy, did you plead true to counts 2, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Good morning. Are you Jacoby Murphy?
Yes, ma'am.
And Mr. Parker, will your client move the formal reading of the motion?
It will, Your Honor.
Mr. Murphy, in cause number 23, DCCR 0900, I have a motion to revoke your community supervision. Shows that you were placed on probation April 1st of 2024 for the offense of theft of property, a state jail felony. And that was, could you make sure, hold on, could you check that and make sure it's fine? Sorry. That was a 2-year term that was probated for 5 years. Is that correct?
Yes, ma'am.
And it alleges in this motion that you violated your probation. Count 1 alleges
Judge, I
that,
believe we would abandon that one. That one was not filed.
okay, just that one.
Just that one.
So we'll, count 2 alleges that you committed the offense of driving while license invalid, March 14th of 2026 in Bexar County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department, March 10th of 2026. Is that true or not true?
True.
Count 4 alleges that you failed to gain permission from Jefferson County, to leave the county and that you were in Bexar County on March 14th of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your arrest from March 14th of 2026. And is that true or not true?
True.
Judge, we can abandon the rest of them if you will.
All right. And so, Mr. Murphy, did you plead true to counts 2, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murphy is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that. If you have any questions about the law that prevents you from having a firearm or how long it lasts, you can talk to Mr. Parker.
Yes,
All
ma'am.
right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Tasia 1 Mac?
Yes, ma'am.
And this is cause numbers 24 DCCR 1046 and then 26 DCCR 0085 and 0086. Mr. Mack is charged with criminally negligent homicide. And then those last 2 are both bell jumping and failure to appears. Mr. Smith, what is the announcement?
We signed
Oh, yep.
rejection.
There it is. Sorry, they were just coming through. Let me go through then. All right, Mr. Mack. In cause number 24, DCCR 1046, you're charged with the state jail felony offense of criminally negligent homicide, and that's from March 10th of 2024. And what that means, sir, is that if you go to trial and you're found guilty in that case, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 26 DCCR 0085, you're charged with a 3rd-degree felony offense of bell jumping and failure to appear from December 15th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 26 DCCR 0086, you're also charged with a 3rd-degree felony offense of bell jumping, and that's from January 5th of 2026. Same thing, if you're found guilty in that case, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for a 2-year term in the state jail prison on that state jail case, and then 5-year terms on the other 2 bail jumping cases, all to run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter pleas of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
Has everything discovery been, you've gotten everything you need, Mr. S, or everything they have as far as you know?
Yeah, Your Honor. However, just to, this court will know, due to my hospitalization, and I truly believe that these cases can be moved if we can get an offer of probation. That is not the case at the moment, but that's where we're at. This is the first offender. He's eligible for probation from a jury. Right now, Mr. Coleman is only recommending print time.
Do you know, Mr. Nichols, who is this going to be yours, or are you just covering today?
I don't know if it's going to be assigned to a judge. I know, it's a homicide case, so I wouldn't expect that part of the offer to change.
Well, except though that the witnesses are going to testify that the shooting is.
Well, that's all between y'all. I don't need to know what all that is.
Okay.
At this point, what I'm going to do is put it on the trial docket.
Okay.
Obviously, if something changes between now and then, I'd rather take care of it well before. So whoever gets assigned to the case, or if Mr. Coleman keeps the case, but either way, if something changes, then y'all let me know. We'll move the case up. Otherwise, we'll take a look at it again on the pretrial date, and then after that, we'll get set for trial.
Thank
Or we'll set up for trial now, but we'll discuss it again in pretrial.
Thank you.
All right, you go back with the bailiff.
The courtroom fell silent as the judge delivered one final warning. Despite the defendant's efforts to seek help and complete rehabilitation, the court made it clear that trust had to be earned through actions, not promises. The judge approved bond but attached strict conditions: no driving, continuous alcohol monitoring, and mandatory treatment. Then came the powerful message: this was his last opportunity. One mistake would send him back to jail, where a 7-year prison sentence could become his reality.
Good morning, sir. You're Samuel Harmon.
Yes, ma'am.
And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed them.
Is the offer, let's see,
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you can turn around and try the next one as well.
Yes, Judge. We'd be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent.
Well, it would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay? The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right, we'll get it set for trial then. You can go back with the bailiff. Mr. Lewis, you have Jason Weinberg. It's a sentencing.
Yes, fine.
Come on.
Yes, was there that what is that? Yesterday, and I think it's the same when he didn't.
Oh, did they not do an? You're right. We didn't get an update.
It's the same one.
So I put him in custody. So he didn't show for the PSI, and I put him in custody so they could go do a PSI, but I didn't get any kind of update, and I didn't notice that. So this is Jason Weinberg, and we had the pre-sentence report done, but he didn't show up. So I put him in custody for them to do that part of it, and I don't show that we have that. Can you check on that for me, and I'll hold the case and see if did probation go out and talk to you? All right, I'm going to reset it 1 week. I need somebody to get out there this week, talk to him so that we can get this taken care of next Tuesday. Please, ma'am. All right, somebody will be out there this week. Sorry about that. Good morning, ma'am. Are you Stacy Tyler?
Yes, ma'am.
And this is cause number 26 DCCR 0800. Ms. Tyler is charged with aggravated assault with a deadly weapon. Mr. Lewis, what is the announcement?
Judge, I've been talking with Ms. Tyler, and initially I was thinking it was just some mitigating information I was going to be getting to the state, but there is some that is material to the facts of the offense. And so I am asking for a little more time to do that, especially considering what the offer is from the state and her exposure.
Okay. And do you already have that, or you're waiting to get that from?
I am waiting on a little bit of it.
Okay.
So but it shouldn't take me too long.
Okay, so I'm just going to do a normal reset, Ms. Tyler, so that Mr. Lewis can get all of that information from you or whoever's getting that to him, get that information to Mr. Nichols, and then we'll get an announcement at the next court date, okay? You can go back with the bailiff. Janae Langerlow, Mr. Lewis?
And we're not going to need her out.
We don't need.
Hold on, okay.
That's a situation where initially she was set for competency, but I refused to see Dr. Capone.
Mhm.
I've gotten that worked out to where they can come over and see her at the jail. See her here.
Oh, I thought that was
And
already going to get done.
we were trying to see if we can do it next week. I've been talking with Dr. Capone's office.
Okay,
We're trying to see if a date can be known where she can be brought over next week.
Sure.
I need to give Kelly on that.
all right, we'll just reset, a normal reset, and we'll get her brought over next week. We're not in trial next week, so it shouldn't be a problem.
Okay.
Mr. Parker, you've got Jacoby Murphy.
Colby Murphy. Yeah. We get the point.
Oh, God, you're right. That's why I didn't give you a breakfast taco. And 23rd? Yeah.
I tried to make it short and then I mixed it up and made it longer and different.
But he was gonna ask you about his time or so.
Oh,
He's asked me 5 times. I'm like, you do that when you get there.
yep.
Okay. Well, I'm not telling how it works because I got my people. I said, no, you do it.
Yeah.
And you go ask her, I'm gonna get it. I said, she doesn't know you. It's not even happy.
Yeah, that's hot. I used to look at all those and do them myself. I would get emails every week, but then they have a way for you to just say, if they say they're doing well, then they can give it. And so I just did the blanket
Right.
thing to quit doing all that every week. Jose Amador.
About time you get a little reasonable on a case like this. For a change. I think you're feeling sorry for her having to deal with a couple of other prosecutors. This guy's been probation for 11 years on state jail, Judge.
How does that work?
He got deported to Mexico.
Oh. Yeah.
Happens.
Good morning. Are you Jose Amador?
Yeah.
And Mr. Parker, will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Amador, in cause number 15-21599, I have a motion to revoke your community supervision. Shows that you were placed on probation March 27th of 2015 for the state jail felony offense of DWI with a child passenger. And that was a 2-year state jail term that was probated for 5 years. Is that correct?
Sure.
Is that right?
Yeah.
Okay. Do you understand?
Yeah.
Okay.
He does.
Count 1 alleges that you violated your probation. It alleges that you committed the offense of public intoxication April 9th of 2019 in Hidalgo County, Texas. And is that true or not true?
Yeah, but
Is it true?
True.
Okay. And then count 2 alleges that you are behind in your court assessed fees. Is that true or not true?
True.
And then count 3 alleges that you did not immediately notify your probation officer of your re-entry into the United States. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Did anybody force you to plead true?
No.
Did you?
Did you plead true because they actually true? Well, yes.
Okay, so all of those are actually true.
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these documents, did you go over them with Mr. Parker?
No.
Do you understand the documents that you signed?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Amador is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and so you can read it so that you understand because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, you can talk with Mr. Parker. All right. Good luck to you, sir.
Okay.
And then Jonathan Hernandez, I'm signing dismissals in all of his cases. He's free to.
Yes, ma'am.
Good morning. Are you Anthony Whitmire?
Yes, ma'am. Good morning, Your Honor.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Whitmire, in cause number 25 DCCR 0057, you're charged with the second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I going to have to start modifying? I think I'm safe just saying it, and
It's like a citizenship thing, because you can't control whether it does or doesn't.
I know.
From being readmitted.
But I mean, they've said specifically that possession is not one of them. In the Hambry case.
It really more says case by case, and I don't think it's such a blanket.
I would continue to give the.
I'm going to say, yeah, as I was saying it, it made me think. Okay, make sure you send that dismissal over on Whitmire, please, and I'll get that signed. And then as soon as hopefully they're going to zoom in on Norris.
Mr. Ernest is a plea also, Judge, if you have it.
Okay, Brendan Ernest. Brendan Ernest. Let's see, we're going on 3 out of the 4. 2.
Everything is very long.
Well, yeah.
Good morning. Are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Right, Mr. Ernest, and cause number 26 DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery, and that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Then, let me take a second. And cause number 26 DCCR 0430. You're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In cause number 26 DCCR 0908, you're charged with a second-degree felony offense of robbery, and that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
So you can't change your mind if I follow the agreement. You understand?
Yes.
And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26 DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Yeah.
All right, you can go back with the bailiff. You've got Vicente Gloria, Mr.
I
Rojas.
think that was reset.
It was, okay. Whose is that? Oh, that one's what? All right, let's let me figure out how to get this done. Second. Print this Norris stuff out so that I can see the Zoom and some of the papers, since I have to do it. All right, Mr. Rojas and Mr. Nichols on Mr. Norris. Good morning, ma'am.
Morning.
Good morning, Judge West.
Good morning, Mr. Norris. How are you doing?
You know who this is, don't you?
Yep, I know who you are. You're Christopher Norris, right?
Yes, Christopher Stevens Norris.
All right, so this is cause number,
Yeah.
hang on just a second. Let me go through some stuff. If you have something to say, I'll give you an opportunity, okay?
Okay.
And you should be able to see on your screen, Mr. Rojas is here, your attorney in court. Mr. Nichols is here representing the state, and this is cause number 0184078. And Mr. Norris was found not guilty by reason of insanity of the offense of murder back in February of 2006, is currently at the Russ State Hospital. And this is our yearly hearing under Article 46C of the Code of Criminal Procedure. I am going to take judicial notice of the court's file, including all of the previous hearings and reports. In addition, I have received the most recent report. I have a forensic psychiatry report to the court, which was prepared by Dr. Gerke, dated June 10th of 2026. The finding in that is that Mr. Norris, that further inpatient treatment would be recommended, and that it is not recommended that he be released to live independently at this time. And then in addition to that, I have a physician's certificate of medical examination for mental illness from Dr. Gerke. The finding in that is also that Mr. Norris is mentally ill, that without inpatient treatment likely to cause serious harm to others. And there's several notations here with some issues that have occurred between now and our last hearing a year ago. Is there any other evidence with regard to further treatment inpatient at this time, Mr. Rojas?
No, Your Honor.
Mr. Nichols? Give me just a second to, all right. Then I am going to find at this time, based on the reports, that Mr. Norris is mentally ill and that further inpatient treatment is required based on I'm sorry, I'm trying to read and talk at the same time. That he does not meet the traditional civil criteria for recommitment, but based on his current forensic type commitment, continued inpatient treatment is required because of the acquittal by reason of insanity with regard to the charge of murder, and that the specific finding is that without that, he would be likely to cause serious harm to others. And therefore, I am going to order the 1 year commitment.
No time to talk. Thank you, gentlemen. I have plenty of paper here I want to explain to you. You know that I have been locked up for 5 years, 8/13/2021 to 8/13/2026. I've been locked up 5 years. On August 13, 2026, I'll be locked up for 5 years exactly.
So, Mr. Norris, here's the thing. We tried several years back.
No, that was 5 years back.
Yep. And that did not go well. And so all I can do at this time is base my decision on the history and the fact that I did, based on, at that time, it was everyone's recommendation that you be released to a kind of an outpatient, more relaxed situation. And that did not work. And so I ordered you back to rest.
I got paperwork showing it says, while I was at Rusk Hospital, I take my meds, take all my meds, learn everything about meds and symptoms, learn my strengths and weaknesses, focus on mental health, take meds, keep appointments. I mean, I do everything that I'm supposed to be doing this year for sure. Work on my goals while I was at this hospital. I've been working on my goals. I understand that mental illness diagnosis is lifelong. Recognizing my symptoms when they are active. I mean, I got plenty. So I'm on resources, housing, transportation, food, clothing, support, medical service. I mean, I got all kind of stuff right here saying that I've been doing in the community, stay away from drugs and alcohol, stay in touch with court. I know that I gotta stay in touch with you if I get out because I know that
So, Mr. Norris, let me interrupt you real quick, Mr. Norris. I can tell you now that if the doctors are not recommending that you be released,
yeah, I haven't talked to that doctor for almost 6 months.
Mr. Norris?
I've been asking for another doctor, and what he wrote up was 6 months back. Because I've been trying to get another doctor.
I've made my ruling at this time. My ruling is that you're going to be continued inpatient at that facility until further order of the court. If something happens and the doctors recommend some other outpatient or.
What if I don't feel safe at this facility anymore? What if I don't feel safe here no more?
Then you need to talk to that facility. I'll talk to Mr. Rojas and we'll look into it. All right. The hearing's over. Thank you.
Yeah, it's wrong though. It's wrong. That's all right.
All right. Keep doing what you're supposed to do and potentially in some time.
I have been doing what I'm supposed to be doing. I have been doing what I'm supposed to be doing.
Well, all right.
That's what I'm trying to tell you right now.
I understand. Continue to do that, okay?
So you just, anything anybody else tells you or you pull up and it doesn't even make sense what you said about the doctor overruling. I haven't seen it for 6 months. How can you write all this stuff about me?
We'll look into that, but the report that I have is dated June 10th. And so, that's what I have to go by. And so I'm going to, again, I've made my decision.
That's gonna be your
And-
decision every time I come in front of you. I don't feel safe at this hospital.
Okay,
That's what I'm
we'll
trying to
check
tell
into
you.
that. All right, thank you. We'll check
You
into
can't
that.
check into it because you don't know how.